Hello, everyone. Good evening, and welcome to the next forum in our series of judicial forums, The Justice We Want Depends on the Judges We Choose. I am Liz Elliott. I am the co-chair of the New Orleans Safety and Justice Challenge Community Advisory Group. Right now at 6 p.m. here, we've got criminal district court candidates for Section L. I do want to make an announcement that there was a bit of a scheduling mix-up. And so one of the candidates, Franz, Zibilich, is going to try and join as soon as possible. So we're going to go ahead and proceed, and then hopefully he'll be able to join us before the end. I want to thank all of our co-hosts for helping organize these forums: Court Watch Nola, Innocence Project New Orleans, SPLC Action Fund, Louisiana Courts Matter, National Council of Jewish Women, League of Women Voters, Orleans Public Defenders, Crescent City Media Group, and Urban League of Louisiana. We want everyone to know that we welcome and encourage public questions, so you can go ahead and put those into the chat. We've got volunteers who are going to be monitoring both the chat here on Zoom and on Facebook, and we'll be getting those questions to the moderators. So right now, I want to introduce our moderator for this 6 o'clock forum, Mr. James Carter, who's our formal council member and current managing partner at the Cochran firm, Trials and Mass Torts. Did I get that right?
Yes, you did.
All right. So at this point, I'm going to turn it over to you, and I'm going to sit back in the background and we will proceed. Thanks so much, everyone.
All right. Thank you so much for the opportunity to moderate such an important panel relative to our criminal justice system in New Orleans. Again, my name is James Carter. I'm the managing partner of the Cochran firm, Trials and Mass Torts. We have a candidate here present who is going to present a 1-minute opening statement as to why she believes she's the most qualified candidate to serve as the next judge in Section L of Criminal District Court. And her name is Angel Harris. Take it away, Angel.
Thank you for having me. Angel Harris, as you stated, I'm running for Criminal District Court Judge Section L, and I believe that I am the most qualified for this position based on my experiences. So I started out as a public defender in Orleans Parish. I also worked as a public defender in Calcasieu Parish. I've worked as a civil rights attorney with the NAACP Legal Defense and Educational Fund. My entire career has been based either in criminal defense or criminal justice reform. And so with those experiences, I would bring a level of compassion to the bench, but also having worked in various jurisdictions, I would bring experiences from those jurisdictions. So I know what programs work and what programs don't work. I also know and have studied the underlying issues that bring people back and forth into the criminal court system. And all of that knowledge would greatly enhance me as a judge on the bench.
Well, thank you for that opening statement. And now I'm going to ask questions to you that were formulated from the coalition of sponsors and co-hosts of this particular forum. And the first question is, what will you do to reduce obvious racial and ethnic disparities in treatment by the court system in New Orleans?
So I absolutely love that question, because part of my career was doing implicit bias trainings for not only lawyers, but defense attorneys and judges. And so I have the training to, one, acknowledge when implicit biases are entering into, entering into a practice. But also, the first tenet of my platform is equal access to justice. If we provide everyone with equal access to justice, then we can greatly reduce the racial disparities that are coming through in our criminal court system. And what that means is treating everyone with respect, giving everyone an opportunity to present themselves, present their cases without coming to or drawing conclusions or assumptions about who they are, simply because where they may be from or even with their background. Because we know that with the disparities in policing, you may have a person who on paper looks like they are a quote unquote career criminal, but when you really pull back the layers and you really look at the facts, you will see that there is much more beyond that in that individual. And I think we need to start having individualized justice. And right now we're not doing that. And that's what's creating the disparities in our court system.
Well, do you support full public funding of the courts instead of relying on bail, fines, and fees to fund part of the court's budget?
I do believe in fully funding the court system. I think it creates a conflict, and it creates a system where you are striving for guilty pleas or striving for fines and fees. And so the third part of my platform is actually stopping the criminalization of poverty. And I think that the way that we are currently doing our criminal court system with bail and with fines and fees, we are creating a cycle or perpetuating a cycle of poverty. When we look at the bail system, for example, the majority of the people who are currently incarcerated pre-trial are there simply because they cannot afford to pay their bail, not because they are a danger to society. And so I think we can't say that we have a system that is just when it's a system that preys on impoverished individuals. And so also with fines and fees, we can't reasonably believe that a person can pay a $5,000 fine for a case, especially if we are incarcerating them. But we also know that through the collateral consequences of a felony conviction, that the earning potential of a person is decreased significantly. And so how do we expect someone to pay a $5,000 fine when they aren't even able to earn enough money to pay that fine, and in addition to that, take care of themselves and take care of their families? And so I think if we were funding the courts outside of fines and fees, then we wouldn't be creating or perpetuating this cycle of poverty. And we can actually create and help have healthier and safer communities.
Well, Ms. Harris, what are the other ways that we can fund the court outside of those draconian measures that one think we're using right now?
And so my platform, my entire campaign is based on reimagining the criminal court system. And so there are lots of ways that we can fund the court system. It's going to take work in conjunction with other elected officials. And I think that there should be collaboration between the courts and elected officials to really sit down and look at the city's budget and figure out where the money is going. When we look at mass incarceration and the amount of money that goes into incarcerating individuals, we really would be able to reduce a lot of that spending if we went to alternatives to incarceration. And so I think we have to really step out of the box and really start looking at where is the money going. Are there ways for us to shift that money and put that into the court system. And I think if we start looking into alternatives to incarceration, that would end up being cheaper for the city than incarcerating individuals.
What do you think is the biggest challenge facing our courts during this time of unrest, social unrest, and global pandemic? How would you address this if elected?
So I think, you know, when we look at COVID-19, I think one of the things that it revealed to us is that, well, something that I've been aware of for a while, but revealed to the general public, is that we actually have individuals who are incarcerated that most of us wouldn't really want to be incarcerated. We have individuals who are incarcerated on very petty crimes. We have people who are incarcerated for simple survival. And I think one of those is really going through and reviewing the cases of who is currently incarcerated and getting those individuals out of incarceration, and really making sure that we are addressing the underlying issues for them. And we know that individuals, when they are incarcerated, social distancing is non-existent in a jail or prison setting. And so with that, we just create incubators for COVID-19. And then from that, it gets spread throughout. And so I think that we really need to be conscious of who we are incarcerating and why, and then making a decision to alleviate the population of jails and prisons. I think when we talk about social unrest, I think people are tired. I think people are tired of not being heard. I think people are, quite frankly, tired of not being seen by the system, not being seen by their communities, not being seen by the city. And that is what's causing that. And I think a lot of that is perpetuated in our criminal court system. I've seen people dehumanized in the courtroom. I also think this is a moment where we haven't really talked a lot about the impacts of incarceration on women and girls, and that has increased significantly over the past few years. In fact, the statistic is the rate of incarceration for women and girls has increased 700%. When you hear 700%, it's mind-boggling, but we're not dealing with that. Because the numbers aren't as large as men, but when we talk about the growth of women and girls that are being entered into the system, it's something we need to prioritize and figure out what's going on.
And when you say 700%, are you talking, what time frame are you talking about here?
So I'm talking about from around the 1970s until now, but one of the things that we need to really look at are the local jails. That's really where the numbers are skyrocketing when we see how many women and girls are being brought back and forth into our local jails. And that's something that's not discussed enough, quite frankly.
You talked about underlying issues that drive criminal conduct, or what's criminal poverty as criminalized poverty. What are those drivers that influence this so-called criminal conduct here in the city of New Orleans and around the country?
So I would start off with drug addiction. We know that drug addiction is a major issue, you know, whether we're talking about Orleans Parish or in the entire United States, and that's not being addressed. We aren't sentencing people to or allowing them to get treatment for their drug addiction. We're sentencing them to prison. A prison should not be a prison should not be a drug rehabilitation center. Also, the second thing is mental health issues. Once again, prison should not be responsible for treating mental illness or mental health issues. We have professionals whose job it is to do that, and we should allow them to do that. The third is poverty. When we are looking at what's driving some of the crimes, we are looking at people who are doing things simply to survive, simply to feed their families. You know, I've said this story on a couple of forums now, but I'll never forget a client that I had who was facing life in prison because of the multiple offender bill for stealing meat out of his neighbor's freezer. He went into the shed to steal meat so he could feed his family. But I was helping him because he was facing life because of some of his prior convictions. And when I think about that, I'm like, why is he here? Clearly, he didn't go into and rob his neighbor's house and take valuables. He took meat out of a freezer. And so that for me is a stark example of how our system has failed our communities.
The past few years have seen numerous stories about prosecutorial misconduct, from fake subpoenas to withholding evidence. What do you think is needed to address prosecutorial misconduct in the courtroom? If it comes to light that a prosecutor has withheld favorable evidence in a criminal case, pre-trial, during trial, or post-conviction, would you file a disciplinary action against that prosecutor? Would you permit that prosecutor to continue practicing in your courtroom?
So I would definitely hold that prosecutor accountable. And I think judges need to do that more often. If someone is, behaving in a manner that's against, the oaths that we have held or against the ethics or professional ethics, then I think that they should be held responsible for it. And there should be a discussion about their behavior, because not only have they violated professional ethics, they are also jeopardizing someone's life and livelihood because they've decided not to follow the rules. I don't see how a judge can stand in judgment of defendants, but they aren't willing to stand and really hold prosecutors and any other lawyer, whether it's a defense attorney that has decided to cross the line. I think that it's unacceptable, and we can't sit in a place of judgment for defendants and not do the same or hold, lawyers that are coming into the court responsible. And I would be a judge who wouldn't allow that type of behavior in my courtroom, because judges are supposed to set the tone and tenure of the criminal justice system. And if we allow other people to skate around the system, then what message are we sending?
Sexual harassment of defense attorneys, court staff, and prosecutors has emerged as a consistent problem in criminal district court, with one criminal court judge stepping down from his judgeship in the midst of a sexual harassment lawsuit. Do you think it's ethical for a judge to have a sexual relationship with attorneys who appear in front of him or her? Why or why not? And what more can be done to prevent sexual harassment and the appearance of impropriety in criminal district court?
I think that judges are in a position of power, and that they need to really be conscious of how they are conducting themselves. Just like I said, lawyers should, be held accountable for their actions. Judges absolutely should be held accountable for their actions. And if they're behaving improperly, then they need to be sanctioned for it. They need to be called out for it. And the public, right now we are in an election. The public has a right to say, not on my watch. The public has the right to say, I won't allow this behavior. And so I think that we need to really exercise our power, whether it's about sexual harassment or whether it's about demeaning or belittling behavior in the courtroom. We all have the right to stand up and say, not on our watch. And I think that there should be trainings. I mentioned implicit bias trainings. When we talk about implicit bias and when we talk about, the isms, it's not just about racism. We also have, sexism. We also have classism. We have ableism. We have all of these isms that come into play. And as judges, we need to guard ourselves against these isms coming into our courtroom. We should be the ones who are making sure that inappropriate behavior is not happening in the courtroom, whether it's by the judge or by someone else who's present in court.
The city of New Orleans, as part of its acceptance of funds from the MacArthur Safety and Justice Challenge, committed itself to reducing the jail population with a variety of strategies and initiatives meant to address the economic, ethnic, and racial disparities in the criminal justice system. Some of these include use of risk assessments in determining bail bond preference for release or RR instead of bail bond, and increasing efficiency in criminal cases. How familiar are you with the city's Safety and Justice Challenge initiatives? And how would you continue to support the city's commitments to the Safety and Justice Challenge?
So I am familiar with the Safety and Justice Challenge. I'm also familiar with the program sort of nationwide and in other jurisdictions. And I think that I would be proud to help uphold that. And I think that this comes from years of studying our systems and really surveying and figuring out what's going on and trying to figure out solutions. And so I would absolutely be on board with supporting initiatives that are coming through, because I think that through collaboration, particularly with people who are, observers of the system and also with impacted communities, that without that type of collaboration and without those ideas and without those initiatives, we will continue to perpetuate the status quo. And it's time for us to move past it.
Court Watch Nola has consistently found that judges will engage in off-the-record conversations, otherwise known as sidebars, pertaining to a criminal case. Sometimes important privileged information is placed on a sidebar, but often important information that would affect the case is also discussed on sidebar and never allowed to be part of the record. Refusing to place important information on the record affects the defendant's ability to appeal his case, since the information placed on sidebar will not be part of the appeal record. What is your opinion about sidebars, and how do you propose to use or not use them if elected?
So as a post-conviction lawyer, I completely understand the importance of having a full record, because I have had to defend individuals who are facing the death penalty and had holes in the record because of because of conversations that were had in chambers or conversations that were had at the bench. And so I do understand the importance of having most of what's happening in the court on the record. I do understand too, though, that there are some confidential things, or there might be some sensitive things that aren't appropriate to be discussed in the public or in the open courtroom. However, conversations in chambers can still be recorded and still a part of the record. And then there can be a designation on that particular thing to, maybe protect the identity of someone or something of that nature. But I think my default is for everything to be recorded, whether it's announced publicly in the courtroom or if we're in chambers still having that conversation recorded. Because sometimes it's not appropriate to have a conversation where the general public is allowed to hear it because of the sensitive nature. But if we are having a conversation in chambers, that should be recorded.
Also, according to Court Watch Nola, bail often remains the same or is raised once a case goes to criminal district court, even if the number of criminal charges someone has had decreased, since bail was initially set in magistrate court. This often occurs although no additional facts have been changed or have changed on the case, other than the prosecutor has now announced the case is a felony. Do you think this is right? Should this practice be changed?
I think the practice should absolutely be changed unless there are new facts that are being presented to the court. If it's simply an amendment of the charge, I do not think that they should be allowed, or I don't think that judges should allow those bonds to be raised. I do want to point out that that is the judge's decision. Oftentimes, judges want to pass the responsibility onto the DA and say, well, that was the DA's choice. The DA decided to do it. But the judge has to approve that bail. The judge has to approve that increase. And, I think, like I said, barring any new facts or anything new coming forth, aside from just a simple amendment, I do not think that it's proper to increase someone's bail. But also, the judge should still go through all of the 10 factors that they are supposed to consider when you are setting a bail for someone. And if they're not going through those factors, then they're not following the law.
A recent study by the National Registry of Exoneration concluded that concealing exculpatory evidence is the most common type of prosecutorial misconduct, and prosecutorial misconduct contributed to 78% of wrongful and false convictions in New Orleans. This is an alarming rate of misconduct. In fact, prosecutorial misconduct in New Orleans exonerations occurs at least 233% times the national rate. What are you going to do to ensure that prosecutors are not suppressing favorable evidence in the cases pending in your courtroom?
I'm going to ensure that any prosecutor that's in my courtroom is doing their job, and they're doing their job ethically, and that I will not tolerate the hiding of evidence, or I will not tolerate, giving a defendant discovery 30, 40, 50 pages of discovery the day before trial. That is unacceptable. There are some circumstances where they may receive, the information at that time, but I will definitely hold them accountable for that, because I think that if we want a true and just criminal justice system, we can't play the games. We have to be honest and we have to have integrity in the courtroom. And if the only way that a district attorney can win a case is by either falsifying or hiding evidence, then that shouldn't make the community feel safe. Because as you've noted, when you look at the rate of exoneration in New Orleans, that's a sad statistic. That's not keeping our communities safer. That is using someone as a scapegoat. And so we can't continue to use individuals as scapegoats in order to get our numbers up or in order to move our docket. And so I think that that's improper, and that I would absolutely not tolerate that in my courtroom.
Some judges, Ms. Harris, at Tulane and Broad impose a trial tax, which effectively adds years upon a person's sentence because they exercise their right to go to trial. And I've experienced this when I did criminal defense myself. This has looked like a judge telling an accused person, if you plead guilty today, I'll give you the minimum, quote unquote, 7 years. If you go to trial and are convicted, the sentence won't be below 10 years. Will you impose a trial tax? If so, why? If not, why?
Absolutely not. As a criminal defense attorney, as a civil rights attorney, I think that it's absolutely shameful that a judge would use that as a bait to get someone to enter a plea of guilty. I think that individuals who are coming into the court absolutely have a right to go to trial. And I shouldn't bully someone into not exercising that right. Also, for me, I think it's very important to look at all of the factors and really figure out what's going on with the case before I approve a sentence. And, when I am talking about equal access to justice, when I'm talking about alternatives to incarceration and stopping the criminalization of poverty, what I am talking about is really looking at these cases and not just blindly signing on to plea offers and not just blindly trying to move my docket. That to me that's not the priority. I will never prioritize efficiency over justice, because for me, it's what is efficiency in our criminal court system if we are producing unjust results. And, that's also how we are ending up with a lot of people whose lives have been ruined by entering pleas of guilty because they are afraid of spending, they are afraid that they will serve 10 years as opposed to 5. And if we are going to ask someone to make a decision that will impact their life in the way that a felony conviction impacts someone's life, we should really present it to them in a way that they don't feel forced or pressure. And judges have to do a colloquy when they are actually entering a plea. And part of that is, were you influenced or forced to enter this plea? Were there any promises given to you? And we know that if a judge just had a conversation and said, if you don't take this deal today, you will get 10 years, then how can a judge even sit up there with the colloquy and say, have you been coerced in any way to enter this plea? When we know that the answer is absolutely yes.
Thank you. The Louisiana Code of Criminal Procedure allows a district attorney to now dismiss a case and immediately reinstate the charges despite the filing of a speedy trial motion. This effectively nullifies an accused person's right to a speedy trial. What, if anything, will you do to protect that right and disincentivize this practice that effectively allows a district attorney to evade the bounds of timely prosecution?
So I think judges have a few options when it comes to that practice. One, admonishing the DA's office and letting them know that that behavior is unacceptable. But two, if they want to do that, then there are ways that a judge can make sure that a person's bond isn't increased or giving that person an ROR. But I really think that judges need to start admonishing the DA's office. And once you admonish that behavior, then they will know that it's not acceptable comfortable. For too long, they have been allowed to play those games. And if a judge makes it very clear, no, you will not do that in my courtroom, then I think that that will change what's happening in the court.
Pretrial incarcerated individuals are treated as though they have already been convicted of a crime in many of the courtrooms in the criminal district courthouse, even though they are innocent until proven guilty. How will you ensure that your courtroom procedures and protocols acknowledge and give true meaning to the law that an accused is innocent until proven guilty and that the accused will be treated with dignity? What are your concrete plans?
So I think that it's simple. I think when a defendant enters into the courtroom, you treat them as if it were anyone else that's entering into the courtroom. You allow them to exercise all of the rights that they have been given. Also, you allow them to, and when I say exercise those rights, allow their attorneys to file any motions that need to be filed and give them the opportunity and the time to file those motions. It also leads to not assuming that someone, or just doing a blanket bail, right? Once again, I talked about the 10 factors, making sure that you are looking through all 10 factors before setting a bail, making sure that you're not pushing individuals to enter a plea of guilty before they have even received discovery. That has happened. As a public defender, there are plenty of times when there was a plea offer given to me and I had no information about the specific facts that my client, or the allegations against my client, and judges pushed for there to be a plea to be entered. I would not allow that type of practice in my courtroom. I think that any individual that comes in front of the court absolutely has the right to know what allegations and what evidence is against them. But also, one of the things that I would do, and I've seen this happen too, is that certain victims don't get their say in a case. So if the victim is saying lock him up and send him away forever, judges will, or DAs will say this is what the victim wants. But if a victim says, I actually don't want this person to be incarcerated, I think this person has a drug addiction, I think this person is dealing with mental health issues, are there other, options for that person? And, then the refrain is, well, this is the DA's case, or this is the person who determines it. So I think it's really time to think about the impact, not only on the particular case, but the impact on the community, and that we are instilling confidence in our community that the courts care about what is a priority for them.
Okay, well, thank you. Now we're going to move from questions formulated from the host organizations of this. The justice we want depends on the justice we choose, the justice we choose, virtual town hall, to public questions from the general public, and we have one. Do you think that that judges have a role in monitoring defense counsel conduct? That is, if you believe that a defendant was receiving ineffective assistance from his or her attorney, what would you do about it?
So, as a former defense attorney, that is something that I would want to address with that attorney. And, and I spoke about this when I talked about accountability for all lawyers that are coming into my courtroom. So not just holding prosecutors, accountable for fulfilling their duties, but holding defense attorneys accountable for fulfilling their duties. And so I think that when we talk about zealous representation, ensuring that, a defendant is receiving zealous representation. And I will make sure, whether it is admonishing or having a conversation with that attorney, or, if I see that an attorney hasn't had a conversation, or recognize that an attorney hasn't had a conversation with their client, yet that client is standing in front of me to take a plea, then stepping back and taking a moment and having that attorney actually have a conversation with counsel before I would feel comfortable entering a plea or accepting a plea of guilty from an individual. And as a person who's done post-conviction work, I think, I am more conscious of when we talk about what is this standard, what does it mean to zealously represent? And so that's something that I take very seriously. And I think we all should. And as judges, that is our role and our duty to ensure that everyone who comes into the courtroom is receiving equal access to justice. And it shouldn't matter if they can't afford to hire an attorney. But that's also, that conversation also makes sure that the pay between DAs and defense attorneys is on par, and that we have an equal system in that way. And, judges have testified before City Council about the funding of offices. So that's not something that is improper. And I think that that's definitely, I would be happy to be a part of those conversations and figuring out how we can create a funding system that allows the public defender's office to pay their attorneys on par with what the district attorney's office is paying their attorneys.
Why did you bring up an interesting point? Why do you think that this system, almost universally, I hear this all the time about the public defender's office not having equal funding to the prosecutorial side, the district attorney's office? Why do you think that's such a big issue right now in society, and it's been for a long time?
So just being very, very transparent, because people don't care about, and I'm using this in air quotes, criminals. People believe that when a person enters into the criminal court system, you talked about this before, even though we say people are innocent until proven guilty, it's often the refrain that a person is guilty until proven innocent. And so with that, people have that in mind, and they aren't as concerned with what type of representation individuals are receiving once they enter into the court. And so I just think it's a sad display of, implicit biases in our system, that when a person becomes system involved, that they are somehow a bad person, or there is somehow they're somehow a bad person, or there's somehow a person who doesn't deserve to be treated with dignity or respect.
Okay, thank you. This discussion is in part about how to fund the public defender's office. Can you share how you feel about how it should be funded?
Well, I don't think that it should be funded through fines and fees or through, traffic camera or traffic tickets. I think that, once again, I talked about this a little bit before, but we need to really look into where the money is being spent. When we think about how much money we're spending on incarcerating individuals, then some of that money, if we reduced the amount of people we were incarcerating, that money could actually go towards funding the public defender's office, funding the criminal court system as a whole. And so I think it's a matter of shifting some of the money that we currently have, and if we implement new practices that don't entail incarceration, or as long of sentences in incarceration, then we could save a lot of that money, and a lot of those resources can go to the public defender's office. A lot of those resources can go into the court or into the system as a whole. Those resources can go into having social workers, that are available to judges. So that way, when we talk about these underlying issues, we are doing it through a level of understanding and knowledge from the professionals who understand those issues.
We don't seem to have additional questions from the general public, so I'm going to move back to questions from the host organizations of this. The justice we want depends on the judges we choose for virtual town hall forum, if you will. Okay. So another one of the questions is, in what ways do you think technology, such as a texting system to remind those with a summons to appear in court, can assist the court in making its process and procedures more equitable and accessible? What other ways do you see technology assisting making the judicial process more open?
I think that we absolutely need to integrate more technology into the courtroom. And I think that people are thinking more about it, especially when we think about COVID-19 and how that has shifted. But I do think having some type of program or reminder system about someone when their court date is, because if you think about the fact that people receive their summons for court sometimes several months in advance. And when you get an appointment for your doctor's office, there's generally some type of system that reminds you that you have a doctor's appointment. And so I think that we need to think about it in that way. Lots of our important appointments that we have that are set months out, we generally get a reminder from those systems. And so I think that would actually go a long way in ensuring that individuals know when their court hearings are. You also have people who their court hearings have been changed back and forth without them even being in court. So there's a discussion between someone, not necessarily the defendant, that something needs to be shifted. And so that then also just ensures that someone is getting that information and that they know what it's about. I think also when we think about a case management system, really figuring out a case management system that will help judges manage what's happening in their courtroom. Also, the docket master can definitely be upgraded. And I also think that so docket master, all of those things can be improved. I think not necessarily on the technology piece, but when we think about interpreters and access to interpreters in court, that can be improved. And so that does have a technological aspect to it when you talk about what equipment is being used with an interpreter. Do you have a person who's simply standing and talking right next to them, or do you have some type of electronic equipment that's reliably relaying what's going on? And so I think those are ways that we can improve the technology in courtrooms.
Court Watch Nola, and thus the public, waited over a month to have access to the Zoom proceedings that occurred for bail bond hearings. These Zoom proceedings have continued, but the public was just not allowed to see them. The public has a right to access all court proceedings except in the rare case that the safety or confidentiality of a defendant, victim, or witness is in danger. Mm-hmm. How would you ensure the public is never refused access to public court appearances again?
So as you stated, the court absolutely has a right, and I think they should be in the courtroom. I think the public needs to know what's going on in the courthouse, because there's a certain narrative that goes around what's going on in court, and people don't realize what's actually happening. And I think if more people had access to court hearings, more people would be outraged. More people would be asking, why are we allowing this to happen? And so I would absolutely ensure that the public has access. I would make sure that there are, the Zoom information is available. And once we shift, back to physical court, I would not bar people from coming into my courtroom, particularly people who are coming to support and be a backbone for someone who's coming into court. It is a lonely feeling to be up in front of a judge and to be up in front of the public. And so to not allow supporters to come into the courtroom, I think is absolutely unacceptable. Unless someone is being disruptive. If they are not being disruptive and they are simply there to show their support for an individual who is in court, they absolutely should be allowed to. And there have been too many instances where people have come, they have taken off work to help and support someone, and they have been denied entry into a courtroom, despite the fact that our courtroom is open to the public, and that is unacceptable.
The Louisiana Victim Bill of Rights requires a court to provide a secure waiting area during court proceedings, which does not require victims, witnesses, or homicide victims' families to be in close proximity to the defendants or their families or friends. Mm-hmm. This right is usually not afforded to victims, making a criminal court proceeding an even more traumatic process. How would you change this subject?
So I would make sure that there are those spaces available, because I know how high tension can be when you have, the victim's family and the defendant's family. And I also know the importance of not having victims in the same rooms. If we want to talk about justice, if we want to talk about, providing a system that's equal and just, then you will have to provide those spaces for victims. And I think judges need to be conscious of that. Judges also need to be trained in trauma-informed responses. And so judges need to be conscious of the manifestations of trauma may have on a person. And so they need to really consider and take seriously how, you know, certain situations can be triggering for individuals. And if judges aren't trauma informed, then they aren't going to understand the impact of triggers, and therefore they're not going to afford the space for people to feel safe and protected.
There are no separate booths for defense attorneys to have confidential conversations with their clients in any criminal district courtroom. As a result, often defense attorneys must have extremely important conversations with their client about private court information directly in front of a co-defendant or other individuals who should not be privy to such information. While sometimes judges will allow defense attorneys to use their private chambers, it is rare this is allowed. How will you ensure that you can have a private booth for attorney-client conversations in your courtroom, or otherwise allow room for these conversations to go forward?
So I would, until there is space for a private booth in the courtroom, I would allow them to utilize my office or to utilize spaces within the courtroom, because I know the importance or the sensitivity of conversations that I've had to have with my clients, particularly when we're talking about incarcerated clients. Because when you have clients who are out on bail, it's slightly easier to find a place, you know, but even then you're still finding a place in the hallway, which is a very public hallway. But I do think that it's extremely important for lawyers to be able to have a private space to have, when you're talking to someone about a decision that impacts their life, you shouldn't have to have that conversation, like you said, in front of a co-defendant or in front of anyone else for that matter. And you just can't really have an open and honest conversation with that individual if you don't have access to that. I think too that we need to make sure that individuals are being transported to court in a timely manner, so that your client isn't coming into court and court has already been going on for, you know, 2 hours, and you don't have time, or you're not allowed time to have a conversation with your client, but it's not your fault that you weren't able to have the conversation, but your client came into court late. And so I think as a judge, they need to be conscious of that and allow that attorney to have the time to have a conversation with their client, and try to provide a space where they can have a private conversation.
Most post-conviction applications filed in criminal district court are pro se applications from imprisoned individuals. Such applications typically receive little attention or are summarily dismissed. Nearly every wrongfully convicted individual from Orleans Parish who was later exonerated because they were innocent filed pro se post-conviction applications that were not taken under thoughtful review. Will pro se applicants have a meaningful process in your courtroom for their filings, which may contain meritorious claims entitling them to new trials to receive meaningful review? What would you do?
So I would give them the same respect and attention that I would in a brief written by an attorney. I think that, you know, and I think part of it is because of my background. I have seen individuals who have written briefs on the back of, you know, envelopes or any scraps of paper that they could put together. And it was quite honestly better written than some of the attorneys that I've worked with. And so I think that we can't discount, because someone is incarcerated and because they may not have the quote unquote education that we assume they should have, but they still know the issues. They've become intimately familiar and they have a motivation to learn it more than some lawyers do. And so I would take it and respect it and read it and give it just as much attention and consideration as anyone else who would file a brief.
Well, we've come to the end of the virtual town hall. The justice we want depends on the judges we choose, and we're going to allow you to give a 1-minute closing statement.
So thank you again for having me. I truly believe that it's time for us to push back on the way that the criminal court system has been handled in Orleans Parish. I truly believe it's time for us to reimagine a criminal court system that's rooted in rehabilitation and not mass incarceration. And that until we do that, we aren't going to have safer and healthier communities, it's time for us to look at the root cause. It's time for us to really pull back the curtain and really dig down deep and figure out what we need to do to help the communities of New Orleans. And I plan to do that, and I have the experience with my varied background, whether it's direct litigation, impact litigation, or appellate work. I have seen things that work, I have seen things that don't work, and I'm ready to implement those ideas in Criminal District Court, Section L. Thank you for having me.
Thank you. And I'm sorry to tell you this, but there was one question that came in right at the time I was saying you had your 1 minute closing, and we want to try to confront it real quickly. Can you expand on the ways that trauma-informed training would have an impact on the way you review cases, real quickly?
Oh, absolutely. So when you think about trauma-informed trainings, I talked about this a little bit, but part of that is thinking about ACEs, adverse childhood experiences, and so how those manifest in certain behaviors, or how those can manifest in certain ways. And I think it helps in the way that I would review cases that are being brought in front of me, and me really looking at the root causes that may be bringing someone into a case, or may be causing someone to react or act in a certain way. It also would help me bring compassion to victims in the cases, because there are some people who say, oh, a victim didn't act in a certain way, or why did she respond in that way? But a person who recognizes the impact and effects of trauma will recognize that not everyone reacts to situations in certain ways, and that their prior traumatic incidences may impact or affect what they are doing. I also would be very conscious of, or make sure that I'm conscious of, any triggers that may impact individuals who come into the courtroom. And being conscious of triggers and the impacts and the effects of triggers, I think makes a judge a well-rounded judge.
Ms. Harris, I'm gonna allow you 30 seconds to restate your closing statement, because we kind of got out of order, and then
Okay.
we close this thing down.
Okay, I absolutely, I think with my background and my experience, that I am ready to push forward for a new criminal court system that's rooted in rehabilitation and not mass incarceration. It's not going to be an easy journey, but it's absolutely necessary. And I think that it's time for judges to do things for the community, to do things for the city of New Orleans. And we need to make sure that we are making proactive steps towards creating safer and healthier communities. And we can't do that without dealing with the root causes. Thank you.
And thank you. And I want to thank the host, the co-host organizations, as well as the listening audience, for tuning in to this very, very important town hall. The justice we want depends on the judges, we choose. Thank you very much. And thank you very much, Liz.
Thank you so much, James and Angel. And I want to thank everyone for watching. We're going to take a quick little break. Our next forum starts at 7 o'clock, where we're going to have candidate Steve Singer for Magistrate Court. So everyone go grab that drink of water, use the restroom. We'll be back at 7. Thanks again, everyone.
Thank you.
That's it.